Good afternoon, everyone. I'm excited to be here today to introduce the SGS webinar for the MDD Validity Extension process. My name is Gregory Jacobson. I'm the Sales Director for the Medical Division. Your speaker today is Balázs Bozsik. Balázs is our Technical Director for the medical devices in the US. SGS is the world's leading inspection, verification, testing, and certification company. We have over 97,000 employees in over 2,600 locations around the world and expertise across 11 global industry sectors. We provide assistance and expertise with global support and services that cater to all industries. We are the largest provider of audits, certification, training, and advisory services. We have the ability to turn your needs into comprehensive solutions with a consistent service delivery via our worldwide network and global footprint. We have highly experienced quality and regulatory experts in the medical device certification area, ready to offer training to you from our SGS Academy. At the end of the presentation, we will have several links for you to the SGS Academy. And an email will be sent later with a link to this recording and a copy of this presentation. There will be Q&A at the end, so please put your questions in the chat box so we can discuss them at the end of the presentation. There's also a survey on your screen. Please fill it out at the end. Thank you for joining us today. To start, I will turn it over to Balázs.
Thanks, Greg. So welcome, everyone. Today we are going to look at the introduction and a little bit of a historical context of how the MDR amendment came to be, what were the triggering events, what was the need for this amendment. We will look at some of the definitions and some of the concepts introduced by this amendment. We are going to look at the eligibility pathways and conditions for the MDD validity extension. We are going to look at SGS's internal process to handle this change. And we are going to take a look at a couple of typical special cases, something that was already asked for by many customers, namely legal manufacturer change and notified body changes together with MDD to MDR transition. We're going to talk a little bit about the known unknowns, some of the things that are still in the works and some of the changes that we foresee in the future, and how manufacturers can handle the uncertainty in their regulatory strategy. After I'm done with my material, I'm going to open it up for questions, and then we are going to go through the questions that you may have that we haven't answered yet. All right, so the background. So you can see that already last year, and of course, this predates, there's since 2017 when the MDR came about, there has always been questions because so many things have been reinforced and the requirements have been elevated. The conformity assessment has slowed down dramatically, and it takes us much more resources to serve a given number of certificates. And this is the same for all notified bodies. So this has been a problem from day one, or an issue from day one, but it now came to the point where there has been concerns, as you can see from the timeline here. There have been concerns from various stakeholders to the point that, the MDR conformity assessment is stifling innovation because it takes so long time to push through the technical documentation reviews. To the point where now concerns have been raised that the lack of certified products may even mean shortages of certain types of medical devices in the European market. So this was obviously unacceptable. And then so different stakeholders started to raise their concerns and called for a centralized legislative solution. That led to Q3 and Q4 starting discussions across different expert groups and decision makers. And in January 6th this year, there has been a draft that was published for comments for the MDR amendment. And then ultimately it has been published on March 15 or accepted on March 15, and that has been published in the official journal in March 20th. So since that date, this amendment is already valid and in effect. Some of the important details. it is important to clarify that this change does not have any impact on any other parts of the MDR. The only part that has been amended was Article 120, which talks about the transitional provisions of how to handle the transition period between MDD and MDR. It gives more time to keep legacy devices on the European market under certain conditions. The notified body certificates, MDD certificates validity are extended automatically if they fulfill the conditions. And one additional provision is that previously there was after the expiration of the MDD certificate, there was a certain set time within which the manufacturer had to sell off these MDD certified units. And this time limit has been removed from the MDR. So even if the MDD certificate expires, the manufacturer can, but the devices have been released under MDD legally, then they can be sold off. There is no regulatory limit. Of course, there might still be technical limits in terms of shelf life or other technical lifetime considerations, but at least there is no regulatory limit. The scope of this regulation, it talks about legacy devices. And legacy devices mean devices covered by a certificate or a declaration of conformity issued under the Active Implantable Medical Device Directive or the Medical Device Directive before 2021, May 21. So any such certificate that expired before is no longer revivable, or it's not part of the MDD extension. So we are only looking at certificates that had the expiration date after 2021, May 21. And so it covers legacy devices, which are covered by the expired or expiring certificates, or devices intended to replace legacy devices. And there's a little bit of disclaimer needed here. This second term is still under definition. So to what degree do two devices need to be similar to be considered a replacement device? In our current interpretation, what we foresee will be the final outcome of this is that basically if you had an MDD certified product and you need to make slight changes, but effectively the product remains the same, but for the sake of MDR compliance, you need to make slight changes. For example, you need to add the UDI string to the label or something like that. Then that would be considered replacement product. And of course, there might be some additional smaller changes in the product, like the declaration of conformity would change to indicate that the product now complies with the MDR instead of the MDD, et cetera, et cetera. But we are talking about smaller changes like this. So you definitely wouldn't allow a complete redesign of the product and still call it a replacement product under MDR. So this is just something to keep in mind. But again, as of today, there is no official definition of how closely a replacement device needs to be the same as the legacy device. Custom-made Class 3 devices are also in the scope, and devices that need not require notified body involvement under MDD, but do so under the MDR, for example, Class 1 reprocessable devices. And you will see later that this comes from the interpretation that when it comes to classification, then the MDR classifications are prevailing. As of the timeline, there are three different timelines. For Class 3 custom-made implantable devices, those MDD certificates or the validity of those MDD certificates can be extended to 2026, May 26. For Class 3 and Class 2B implantable devices, these are collectively considered high-risk devices by the regulation amendment. They can be extended to 2027, December 31st, and any other lower class devices that require notified body involvement can be extended to 2028, December 31st. As I mentioned already before, when there's a difference between classifications in MDD and MDR, the MDR classification is applicable. if you had an MDD certificate that covered different classes of products, then the current information is that the last date applies to all, but this may change in the future. So we may need, if the regulators call for it, we may need to detail that for each product group, we may prescribe different extension dates. But as it stands today, if you have class 3 and class 2A devices, for example, on the same MDD certificate, then we would offer you the longest validity extension date. The validity is automatically extended for the dates on the left, regardless of when the MDR certificate is issued. So, for example, it may happen that you are already in progress with your MDR conformity assessment, but your MDD certificate would expire, for example, this October, let's just say. And then we wouldn't say that we would only give you the validity extension until the MDR certificate is issued. We would give you the validity extension confirmation letter up until the date that your devices are eligible for. So I think that's an important condition or important detail. The other thing is that the validity extension expiration is not impacted by the MDR certificate. So we will not say that on the day when we issue you your MDR certificate, we will automatically need to repeal your MDD validity extension confirmation letter. Those things can be in place in parallel. So in many cases, manufacturers may want to take advantage of this and sell off their remaining MDD compliant stuff up until these dates are allowing the manufacturers to do so. The important part, of course, the downside or the cost of it is that so long as you have this parallel system in place, or the two parallel systems in place, you will be financially responsible to pay also for the MDD surveillances. So despite our previous maybe speculations or forecast, it seems like that the requirement is that in this period, for these devices that are subject to the MDD validity extension, separate MDD surveillances will need to be performed on top of the regular MDR conformity assessment elements, but just the audits. So as you can see in the next bullet, we don't foresee that we will need to perform MDD unannounced audits or technical documentation reviews anymore. Or also we had for a while what we call the truncated review. So we don't need to do any of this unless we have evidence of a public health threat or safety concerns related to these devices. So if there's no safety concerns or public safety health threat or public health threat, then we don't need to perform unannounced audits and technical documentation reviews under MDD anymore. I don't know if this slide is properly visible. You will be able to look at it in more details when you will get the slides. I'm just going to go through this on a high level. So this just shows the realistic timeframes of how the timeline will look like from now until 2028. With a couple of considerations. So we have to understand that the MDR certification is a long process. We normally give a careful estimate to our clients ranging between 12 to 24 months, depending on the risk class of the device. But as you can see on this time frame, it may even go up to 51 months in a worst case scenario. The next year, what we foresee is that between May and September of 2024 is going to be very, very busy on the notified body side. We will be really overloaded with all the contract activities. Plus, of course, Europe, they have an extended summer leave for some of the key people. So things are going to slow down next summer. So this will also just emphasize that you shouldn't wait until the last minute to take steps on this one. The sooner you act to start your transition to MDR, the sooner you can reserve your spot into the whole workflow. We will operate on a first come, first serve basis. The sooner the MDR certificate is issued, the sooner we can stop this MDD surveillance. So that can save resources on the manufacturer. It also saves resources for the notified body. So it's our common goal to get all of our manufacturers through this transition as quick as possible. And in order for manufacturers not to just purely reserve the spot and then do nothing, there is a maximum 1 year gap between signing the MDR contract and starting the stage 1 audit. So this is to make sure that things are moving along in a good pace. Of course, this puts some expectations on the notified body personnel and resources as well, but that is our commitment that we will be able to deliver this. But we also expect manufacturers to take steps and prepare their QMS and technical documentation to be ready by the time of the audit. So it's not only about signing the contract, but then really effectively starting the conformity assessment. So in the timeline, you can see from May 2024 all the way up to December 2028. You can see that it starts with the step of application, filing an application to the notified body of your choice. Then you sign the contract. And so in between, there's a couple of things to take care of. So filling out the questionnaires, product questionnaires. We have internally, need to set up the contract, do the contract review, set up a technical file review, sampling plan. So these are all quite labor-intensive processes. We have to often go back already on the questionnaire where it is inconsistently filled, or when manufacturers are not structuring their technical documentation in a way that allows us to really segregate the technical documentation reviews, or when we see clear information that the manufacturer is not yet ready at all because certain basic information is not in place. They haven't made, I don't know, there's a bunch of TBDs in the questionnaire or in the product information questionnaire, then simply we have to push back and ask the manufacturer to fill out the missing information. And we have a maximum time in between the approved CWS. CWS is our internal, we call it a contract worksheet, and that is essentially approving a project for the full certification cycle. So that's our internal document that shows that the project is approved. And we have maximum 3 months between the approved CWS and the contract signature. And then the next step is that we sign the contract. And then we have a maximum 12 months between the contract signature and start of the stage 1. That's the same as here. And the next step in our workflow is that we have to start a stage 1 audit in which we evaluate the preparedness of the manufacturer for MDR. Once they survive or pass the stage 1, then in parallel, we set up 2 activities. One is that we are preparing for the stage 2. So we are scheduling the stage 2. We are setting our resources up to start the stage 2. And then in parallel, based on the technical file sampling plan or review plan, we are going to start scheduling the technical documentation assessments. And usually takes 6 to 18 months, actually, after the approval of the stage 1. And once the technical documentations are ready, it may take a couple of rounds. Then we need to close the non-conformities. So if there's any major non-conformities, for example, during the stage 2 and the technical documentation review, the manufacturer has 1 year to close these non-conformities if they want to continue the process. If they cannot close it, if the gaps are so big that they cannot close it within a year, then the whole process will be shut down with a negative result. Yeah, basically after that, we will issue the certificate depending on how soon we can do so. And in the bottom, you can see 3 different timelines. One is the minimum certification time, The one is the kind of the realistic certification time, and the third one is the worst case. So the minimum one, if everything goes well, is 11 months. In a realistic way, it can be, I think it's 28 months written here. So it's a little bit over 2 years from the very beginning to the very end of the project. So that's like a conservative estimate. Again, this goes along with this 12 to 24 months that we usually communicate to the clients when they sign with us. But in worst case, it can go up to 51 months if everything is maxed out. Obviously, this is also not a realistic time. This is like exaggerated. So some further definitions of what we of how we apply this amendment. We talked about certain conditions previously. So the conditions to be fulfilled is that the QMS should be MDR compliant, and an MDR application should be lodged with the notified body before May of next year. And then the MDR contract needs to be signed between the notified body and the legal manufacturer before September 24 next year. We talked about valid certificates. So what do we consider a valid certificate to handle in the context of this amendment? So it's either valid at the date the postponing regulation enters into force, so it's valid as of today, or it can be an expired certificate, but for which the manufacturer got an MDR contract with the notified body signed before the expiration. So that's the second path. And the third one is an expired certificate if you didn't have an MDR contract before this MDD certificate expired, but for which the EU National Competent Authority granted a derogation. So the derogation process is handled in a different MDCG guideline, and there are literatures explaining the derogation process. I'm not going to go into that one now because by now it is largely obsolete. So if you previously got a derogation for your certificate, then that can also give you a pathway into the validity extension. In terms of devices, I already mentioned that the to-be condition is that the devices shall not present an unacceptable risk to patient health and safety. We are using the manufacturer's own post-market surveillance data for evidence for this. And this was already the requirement, actually, by the way, for the derogation process. So this is kind of nothing new in that regard. And the second condition is that the device should not have undergone significant changes in design and intended purpose in accordance with the MDCG guideline 2020-3. It explains what is considered a significant change under Article 120, and that is still relevant for this discussion. Yes. The next one, as I mentioned, there are two special cases that gave us a little bit of a headache, but a lot of manufacturers asked for them because life goes on, and changes do happen regardless of whether the regulatory framework is ready to handle such changes. So two of the biggest ones that I think are noteworthy is change in the notified body. So if you had one notified body for MDD, but you want to change over to a different one for MDR, maybe your previous notified body is already out of business, or they don't have the capacity to handle your case, or you were just not happy with their level of service and you anyway want to have a different notified body for MDR. The validity extension explicitly makes this possible. And the manufacturer can decide which notified body should perform the remaining MDD surveillance audit. So it's entirely up to the manufacturer. Of course, it may depend on the capacity and the willingness of the notified body, the previous notified body, to handle this. But it's up to the manufacturer and the notified bodies who should do this. So the regulation allows both notified bodies to handle this. In any case, this will require a tripartite agreement. So all three parties have to sign. The legal manufacturer and the two notified bodies have to sign this. On the other hand, if there is a change in legal manufacturer, it is generally possible only if the change is administrative in nature. That is, that the name change of the same legal entity, but there is no significant change in the QMS. So it's not that you move the manufacturing to a different location, or it's a completely new QMS because the manufacturer has been absorbed into a bigger organization or something like that. So if this is the case, if it's just an administrative renaming of the legal manufacturer, it requires some extra time during the next audit, maybe 1 or 2 days, when we verify all the information and updates to the administrative part of the technical documentation that already shows the new name and address. Also in the design documentation, there might be some other interfaces to the quality management system, but this one is generally possible with just a little bit of extra audit time. But if there's any bigger changes, like a proper legal entity change, it is currently not possible. Per the MDCG 2020-3 is the same guideline that talks about what is a significant change of the under Article 120. So that is also the guideline that explains that smaller administrative changes are possible, but no legal change, no change in the legal entity. But since a lot of manufacturers are asking for this, and they ask for a uniform and consistent solution, and not just from our notified body, but others as well, Team MB is currently in discussion with the EU Commission. They plan to discuss it in their next meeting, which is expected to be held by the end of May 2023. So by beginning of June, likely we will see some updates. Hopefully it will allow manufacturers to take advantage. If they can prove that there is a pedigree of succession between the previous legal manufacturer and the new manufacturer, hopefully there will be a legal situation where they can take advantage of the MDD validity extension. But again, as it stands today, it is not possible. Also, it's worth to mention that there is a default 6 months grace period after the change to sell the devices labeled with the previous legal manufacturer's name and address. So that's that's even there with the removal of the sell-off period. This is still a general expectation for the from the notified body. All right, so taking all this information into account, what do manufacturers need to do, how to plan ahead, and what to do next. First, should be for everyone, it should really be clear that you need to move ahead with the MDR. Again, it may come down to the regulatory strategy of the manufacturer. If you say that, Europe is just not worth it, you don't make enough sales, or it's too hard or something like that, or you just want to down prioritize it, of course, that's your right to do so. But if you decide that you want to keep selling in Europe, then you will need to move on to MDR. You should not delay. The second step is very important. You need to self-assess the eligibility based on the criteria and the definitions that I have mentioned earlier. You will be very easily see if your products and which of your products are eligible to participate in the MDD validity extension, and which of the products are not, and under which pathway. Do you have a valid MDD certificate, or did you sign an MDR agreement before the MDD certificate expired, or you may have a derogation letter from the competent authorities that allows you to keep selling to Europe. So if you have any of the three and your devices are still considered safe in Europe, then based on post-market information, then likely you are eligible to participate in the MDD validity extension. If that's the case, if your self-assessment determines that you are eligible for this, then keep selling to Europe. So regardless, again, of the expiration of your MDD certificate, if you yourself consider that you are eligible to participate in this, then please don't skip a single beat. Just keep selling to Europe. The deliverables from the notified body or from other parties are kind of a reinforcement in this process, but likely you will not face any resistance from the EU customs officers. For example, if you just send them the evidence of your expired but at one point valid MDD certificate that covers these products, you should be just fine for now. They are obviously also trained to exercise some flexibility in accepting these products in this transition period. So it's a very important message that you don't have to wait from anything from your notified body. Just keep selling. Okay, you don't need to miss any business or have any outages just because of this transition. So that's a key point. The next one closely related to this is find a notified body, update your quality management system and technical documentations to be MDR compliant if you haven't done so already, complete the MDR application before next May, sign an MDR notified body contract before next September, then submit a compliant MDR technical documentation to allow the notified body to complete the conformity assessment before the end of the extended timeline, and then just be less stressed about the certificate expiration. So these are the main steps going forward. Just this is definitely not meant to, add to the confusion, but just a little bit of an internal workflow of what are the decision charts that we use internally. And this is already part 2 of the decision. Once we, in the previous flow chart, we determine that the manufacturer can get extension of their MDD certificate, then basically we look at whether is there another notified body involved in this. Then we have to have this transfer agreement. We have to set up a contract to cover the MDD surveillances. We have to plan these activities. We have to send a confirmation letter to the manufacturer, and then if any critical issues are detected, then we can, of course, cancel this at any point. Otherwise, we will just plan our MDD surveillances for the remaining time until whatever year was indicated on the confirmation letter. So this is the general workflow. Our notified body is already prepared to meet this demand. For the contract, there are a couple of maybe additional smaller details that you might want to know. So the addendum contract, we are using a certain template to cover additional surveillance audits with the possibility to conduct technical file reviews and unannounced audits when there is a risk to public health or patient safety, as I already mentioned before. We have a template for the confirmation letter itself. For manufacturers outside the EU, we need to indicate the EC rep name and address per the last audit report. We need to add the single registration number of the manufacturer as available on our internal documentation. So please be prepared to have that number. We need to indicate a signed MDR contract information with SGS or another notified body. If there is a derogation, we need to include details of this derogation. So obviously you would need to submit us the approved derogation letter so that we can copy the details. We need to include the eligible product groups. And it is important to point out that only those which are covered in the MDD certificate and part of the MDR conformity assessment process. So these conditions both need to be met for the products to be eligible in this conformity assessment or in this validity extension. We need to include their MDR classifications to make sure that you have that ready, and substitute device information if that's relevant. So in some cases, if the device that you want to put that is part of the MDR conformity assessment is different than what was in the MDD, and you have to explain how this one device is a substitute or replacement for the previous one, for the legacy device. And then we also have to put in the MDD certificate number and the issuing notified body information. So again, you can see that we are not very picky whether we are one or the other party and another notified body is involved. This kind of collaboration is now expected from the regulators in order to help our clients. And then this confirmation letter, it's not a certificate, but it will be a control document. And if there are any changes, like for example, if you want to add or remove products or some administrative changes, in that sense, it a little bit behaves like a certificate. So we have to maintain control over that. It will also have a revision history, and we need to track the changes in this confirmation letter. So that is the format, but it's a different format than the letters, the amendment letters that we have previously affixed to your MDD certificate. So we will no longer keep amending that certificate. Obviously, we cannot issue new MDD certificates. So this will be a completely separate confirmation letter, and it will have its own life cycle and revision history. All right, so that's pretty much it. And now the question is, now what? Of course, I would like to maybe check some of the questions that you may have had. So let's take the first one. So I hear from one manufacturer, our certificate expired in June 2022. We had a contract for MDR. Can we ship now? Yes. So again, this is, you should just, you should keep selling. If you feel, or based on the self-assessment, you determine that you are eligible for this validity extension, then please keep selling. You don't need any other deliverable from us right now or any other notified body. You will get your confirmation letter. Obviously, beyond a certain point, the import officers and the customs officers will ask for some sort of proof that you are participating in MDR. But for right now, for your immediate use, every manufacturer just keep selling if these products were previously MDD certified. Next question. When we say notified body certificates validity will be extended automatically, are we going to get an official letter for those certificates or updated certificates? Okay, so again, we don't update any certificates. The confirmation letter will be its own thing. But the process is automatical in a sense that we will offer this automatically to all manufacturers who were once certified by us or who have started an MDR conformity assessment with us. So this is basically will be offered to every qualifiable manufacturers. And then, of course, because the MDD surveillance audits will present an extra financial burden, the manufacturers will need to agree to take on this extra opportunity or extra cost, depending on where you look at this. So we will offer this to everyone automatically, but in order to take advantage of that, you will need to agree to be subject to the MDD surveillance audits, the additional MDD surveillance audits. So that's how we mean that it is extended automatically. And then, of course, because this requires a separate contract, upon signing the contract, we will set up this cycle automatically. Also, it means, automatically also means that there is no additional assessment or additional audit or additional review that is needed in order for us to grant this extension. So it's, in that sense, it's also automatic. That there is no additional evaluation. If your products meet these administrative eligibility criteria, then the extension will be granted to you. The next one was, will the validity extension letters be sent to all clients, or do we need to request them from SGS? So again, we need to first sign the addendum contract that I mentioned in one of the previous slides. So this addendum contract will need to be signed, and upon signing the contract, we will send out the confirmation letters. The next question was, will SGS be performing MDD surveillance audits while under the MDD extension? Yes, and that's what we have the contract for, and that's what we, basically that's what the contract is for. So we will not do technical file reviews and unannounced audits routinely, but we will do MDD surveillances. Next question, what should the manufacturer do if, in our case, submitted 4 technical document files in May of 2022, but have yet to receive any follow-up reviews? Is this delay common? Will we receive confirmation letter for the purpose of the MDD extension? That's a very important, and that's a very good question. A very important thing, maybe I have missed to mention that, but it is not a condition. If we go back to this slide, it is not a condition that that there has to be certain progress in your MDR conformity assessment. So the whole point of this MDD conformity or validity extension is to bridge the gap or just extend the timeline, because notified bodies currently don't have enough capacity to certify everybody on time. And that's why it is obviously not a condition in this whole validity extension that there should be any sort of progress in the MDR conformity assessment. So that's why the requirement is even just to file an application, not even to sign the contract. So as you could see, the contract will need to be signed by September next year, but just to have a signed application that you want to participate in this process, just to signify your intent, that's the minimum condition to participate in the validity extension. So definitely it is that allows the notified body time to finish the pending technical documentation reviews or audits, while the manufacturer can keep selling their products under this special circumstance of the validity extension based on their previous MDD certificate. So I would say that there are some delays. That's the whole point of this validity extension at different notified bodies. I don't know if it's normal since last May to still have 4 technical documentations pending. I definitely cannot comment on that. It can be a combination of notified body resource shortages versus a lot of pending items, a lot of non-conformities or open issues with ongoing or completed technical file reviews. I cannot really comment on that, but for the purpose of today's discussion, that's the whole point why we have this. So you should have no outages, and if you have your MDD certified products, and then you can still keep selling them in the meantime while the MDR conformity assessment is finishing up. Hopefully it will be done before 2027 or 28, depending on the classes of your products. So you should not miss any business in the meantime. But of course, you can always keep the pressure on your notified body and ask them to, pick it up a little bit, if they can. But I'm fairly certain that they know by themselves anyway that there's no, time to waste. The next question was, no unannounced audit under MDD. This is only after the expiry date of the MDD certificates. Can you please elaborate? That's a good question. I think I will need to follow up with the notified body. But if that's a good question. I think if I remember, we said that we have already canceled all of the MDD related activities other than the surveillance audits, even starting 2022. And so I would say that even as of today, you should have no MDD unannounced audits if you already have started the MDR conformity assessment. So that would be my first guess, but definitely I can follow up on that for you with our global team. Next question, what types of devices can SGS take on for MDR? I think that's a little bit off topic. I will definitely circle back to that. I know that our 2 focuses for new clients is orthopedics and medical software. That's 2 of our focal areas, but generally SGS as a notified body has a full scope, so we can take on pretty much everything. When the question is related to where do we have shortages for product assessors or what, in which device groups, that's an ongoing changing topic. So I would need to follow up the global team with that. And yeah, actually, I can circle back to you on that one, okay? Next question was, our MDD certificate will expire in May of 2020. Oh, sorry, there was some jump here. Our MDD certificate will expire in May 2024. Will our certificate will automatically extend it if we sign the MDR contract with SGS? Do we need to have a recertification audit? So to clarify, it will not be your certificate extended. It will be you will get a confirmation letter that you can keep selling your devices. So we will not touch the certificate. That's just a small technicality, but I think it's important to clarify. So you will get a confirmation letter, and you will have this contract. It doesn't have to be SGS, it can be any notified body. This rule should apply, but if you sign the MDR contract with SGS, then you are eligible for the extension. As I said, you don't even need to have the MDR contract signed, you just have to file the application. When you, for example, in case of SGS, you fill out the MDR questionnaire, you will keep get in contact with our sales team or our key account specialist, and you will fill out the MDR questionnaire. That means with the appropriate product information questionnaires for each of your product groups, then that already constitutes as that you have lodged an application with the notified body, and that already allows you the eligibility for this validity extension. Do you need to have a recertification audit? You don't have to have any audit or any assessment. As I said, just filing or lodging the application is sufficient to be eligible. And then, yeah, things will go from there. But no progress or no assessment are necessary. Do we need to ask SGS for the confirmation? Does SGS automatically process this? So SGS will reach out to all eligible manufacturers and will offer you the opportunity to participate in the validity extension. If you choose to participate, we will ask to sign an addendum contract. And if you accept the addendum contract, then you will get the confirmation letter. That's how it goes. Next one, do we have to apply for the extension of the MDD certificate? Isn't this automatically extended? Again, yes, it's automatical in the sense that there is no additional hurdles in the way, but you have to sign the addendum contract to allow us to perform the MDD surveillance audits for the remainder of the cycle or the remainder of this extension time period. The next question was, certificate will expire on 1st of May 2024. Do we expect recertification audit this year? And if yes, then our QMS should be in compliance with MDR Article 10. So for MDD, we don't do recertifications anyway for a long time now. So there's no recertification audit. You should just keep selling, but you will get a surveillance audit this year. So if you sign up for this validity extension, and if this year you haven't had an MDD, so yeah, if this year you, I would say within the validity, so until 1st of May 2024, if that's when your certificate will expire, you will be subject to the regular conformity assessment under MDD. So until that whatever is the current condition for your MDD conformity assessment, so that cycle will run off. And after the MDD certificate expires, then this extended validity extension special remaining cycle will kick in, which will be just limited to the surveillance audit. So there will be no recertification audit whatsoever, and any further audits will be just MDD surveillance audits. Next one, our certificate will be expiring in October of 2023. At the moment, we are not MDR compliant. Can we still start the process of filling the MDR application and get the confirmation letter? Oh, this is a really good question, actually. I would like to answer this in a little bit broader context or broader setting of how ready manufacturers need to be in order to apply for MDR, which is a question that we get a lot, even for manufacturers who already filed the application. So the general expectation is that you should be ready by the time of the stage 1 audit to show us what you have in terms of the quality management system. So at least with SGS, you will not get major nonconformities during the stage 1. If we see that something is so immature or so unprepared that we cannot reasonably assess that you are prepared for the stage 2, we may stop it. And we may postpone or make recommendation to postpone the stage 2, but we don't issue non-conformities per se. So there's we may ask you to fix up certain things by the time of the stage 2, or we may advise that certain open items may turn into a non-conformity during the stage 2, which may even be major non-conformities, but we are quite permissive during our stage 1 process. So if some things need to be finished up at the time of the stage 1, maybe you will survive that. As for the but surely you will get major nonconformities easily in the stage 2 if there are still open items and you're not full and your QMS is not fully compliant with the MDR. As for the technical documentation, already in the stage 1, there will be some questions asking us to confirm that your manufacturing processes are in compliance with the process documented in technical documentation. So if the technical documentation is not ready, we will not be able to answer that question. So again, you may have some of these open items in the stage 1, but likely we will be able to move on to the stage 2. If the same problem still happens during the stage 2, then you will get nonconformities. Another question is whether if there's a sampling plan, do all technical files need to be ready, or if the manufacturer already knows which products will be subject to the year 1 technical documentation review, is it enough to just have those technical documentations ready and keep the rest open and to finalize based on the feedback from the initial round of the technical documentation review and just have those ready by the time the MDR certificate is issued? I would say it's again a gamble. Our nominal expectation is that all products and the full QMS should be fully MDR compliant by the time we start the conformity assessment. So this is pretty black and white. Everything needs to be ready. The longer you keep things open, the more chance you have to have non-conformities. So that's what I can say. We are, because we are not going to start reviewing your QMS and your technical documentation on day 1 when you file the application, we won't know. So maybe that's a reasonable thing to reserve your spot some time ahead and just finish up as you're waiting for your actual stage 1 date. That might be a reasonable approach. But you have to pace yourself in a way not to leave too many things open so that you have some assurance that that you will be able to finish up everything that needs to be finished up by the time of the stage 1. So usually you have to have a good degree of preparedness or overhaul. If you previously had an MDD technical documentation, to overhaul it to be compliant with the MDR, you have to be there to a large percentage to just do the finishing touches as you're waiting in your spot. If you haven't done, major parts of your, clinical evaluations and external testing of your device, et cetera, those couple of months while you are waiting for the administrative process to catch up might not be enough to be there. And then you have just wasted all your time and money for a process that will not quickly result in a usable certification. So I would say it's a judgment call. Just be sure to be ready by the milestones that I have mentioned. Next question. If we add 6 devices in MDR transition contract and later, can we add one more device that in that signed contract? Yes, because of the long turnaround time, our notified body is very flexible in this regard. So there are 2 maybe main scenarios here. One is when a manufacturer initially knows that they want to have a staggered certification for the different product groups. So a lot of manufacturers have a strategy to, if you have, 50 different product groups, then you will just make a representative selection of these different product groups based on different risk classes, different technologies, different, maybe animal tissues, different sterilization technologies, whatever might be a representative difference. And just start with that first batch of products and then learn how the technical documentation goes, and then take that information back and update the rest of your technical documentation to reduce the number of or the amount of rework that you have to do. So that's one strategy. Obviously, the downside is that the second batch of products will be certified later. But the benefit is that you have less rework. The other strategy is to put all your eggs in one basket and start all your products, and then that runs the risk that if there are systematic errors in your technical documentation, then that needs to be reworked in all the technical documentation. So that's a little bit of a gamble. But if everything goes well, then all your products will get certified at the same time. So that's the benefit of that strategy. So it's your judgment call of how you want to drive this, how much confidence you have that you initially draft up a good technical documentation. So that's one scenario of intentionally already deciding. In some other cases, manufacturers start with a certain selection of products, but along the way they get more products, maybe through merger and acquisition, maybe some design projects just come on board and they need to be added to the scope, or maybe you had to have some design changes and initially you wanted to handle that under MDD, but now it has to be added to the scope of the MDR prematurely. So these things can happen, and in those cases we can add them to the scope of the MDR certificate. You still have the choice of saying, I want to hold off onto this and just have the certificate issued, and then I will add them later. Or if you need to do so, you can say that, okay, I want to add it to the scope. And depending on the sampling, we may need to review these newly added products. But if they are just more of the same of what we already have, and then they don't make the sampling, then it may not even have a big impact on the outcome and the timeline of the certification. So it really depends on the special circumstances. And then we evaluate these cases one by one. In some cases, we may advise or just draw the attention of the manufacturer of some of the pros and cons that they will have if they add products immediately, or whether they wait until the certificate is issued. So these things are possible. We have flexibility, so we can find out what is most value added for your business purposes. And I think that was it. Maybe I would give the word back to Greg, and so that he talks about the trainings from SGS.
Thanks, Balázs. Great presentation. So at the beginning, I promised that we would have some links for SGS Training Academy. You'll get an email shortly with the link to this presentation, as well as a copy of the presentation. And in it, the link should take you right to the page to sign up. So there's a training for technical documentation, implementation, clinical evaluation, and internal auditor training. I hope you can sign up and join us for these trainings. But I think that's it. If anyone has any questions, you'll have our contact information in the presentation. Please reach out directly to either Balázs or myself. We're happy to answer any questions or set up a call. But for now, that's it. Thank you for joining us. Appreciate all the questions. An important topic for everyone in this transition. Wish you all a great weekend, and thank you very much. Take care.
Thanks, everyone. Bye-bye.